Quick note before we jump in. Where I practice in Pennsylvania, revocable living trusts are not the standard go-to estate planning tool. Probate avoidance, or making efforts for certain assets to avoid probate, can still be a very useful strategy, but it has to be done carefully and intentionally. And this video is all about what happens when it's not done properly. So let's dive in. When people talk about their health, they might say, my goal is to exercise more. And that's great. But a good doctor or health coach might ask, why? Usually the answer is something bigger: to have more energy, to feel better overall. And from there, the conversation expands. What about your sleep? How's your diet? How are you managing stress? Because real health isn't just about exercise. It's about the whole plan. Estate planning works the same way. People will often say, I want to avoid probate. And that sounds like a clear goal, but it's really just like saying, I want to exercise more. It might be an important piece, but it's not the end goal. When I dive deeper with clients, we usually get to a point where they say, I just want to make things as easy as possible for my loved ones. I can tell you, I have witnessed too many times where people have made things much harder for their loved ones in the name of probate avoidance. So let's agree on this. Probate avoidance is not a goal. Good planning is a goal. And just like your health, good planning for your estate means looking at all of the moving parts, not just isolating one piece. Now let's break down a really common mistake that I see way too often when settling estates, especially when people are trying to avoid probate. So the first thing to understand is that when someone dies, there are expenses that have to be paid. A big expense in Pennsylvania is Pennsylvania inheritance tax. And it is very common to see a provision, particularly in older wills, that says something like, I direct that all estate and inheritance taxes shall be paid from my estate. And just as a reminder, Pennsylvania inheritance tax rates vary depending upon the relationship of the decedent and the person who is receiving the property. So it's 0% for a surviving spouse, 4.5% for children and grandchildren, 12% for siblings, and 15% for virtually everyone else. Now, keep in mind, and there's a lot of confusion about this, just because you avoid probate does not mean that you avoid inheritance tax. Even assets that pass outside of probate are subject to an inheritance tax. The only broad exception to this is life insurance. But inheritance tax is just one piece of the puzzle. There are also real-world expenses that come with settling an estate. These include things like funeral costs, medical bills, credit card balances, property bills, things like utilities, taxes, insurance, legal and accounting fees, potentially executor fees. And almost every will has a provision that says something like, I direct that all of my debts, funeral expenses of my last illness, and all other expenses shall be paid from my estate as expenses of administration. So we covered all of the expenses that might come up when settling an estate, and we looked at some of the common structures under a will, and all of that makes sense. But here's the big mistake. People are often advised by well-meaning financial professionals to name beneficiaries on all of their accounts. The idea is to avoid probate. So life insurance, the brokerage accounts, the checking, the savings accounts, they all pass outside of the estate. And that sounds efficient until you realize that the estate now has no money left to pay expenses and the executor is stuck. So they might have to go to court to try to claw back funds, or at least go ask the beneficiaries to contribute some money back so they can cover expenses. And that may not go very well. So through ill-conceived efforts to avoid a court process, probate, you end up right back in the place that you're trying to avoid to begin with. And this time, it can cost a lot more than the cost of probate. I've seen situations that cost estates thousands of dollars in legal fees, all in the name of probate avoidance. Now, look, I want to be very clear about this. I am not anti-probate avoidance. Structuring accounts to pass directly to beneficiaries is a very good idea when it is done as part of a comprehensive plan that addresses the things that we're talking about. So this means coordinating with your attorney, talking to your financial advisor, making sure that your estate is funded to pay the death-related costs and expenses. If it sounds like I'm frustrated, I am, because the mistakes that I see are not the fault of the client. Most often, it is abundantly clear to me that the attorney and the financial advisor were operating on two separate planets. These are the people that clients are trusting to help them reach their goals, and they have failed them. Sometimes this issue is caused by the unawareness of the financial advisor. Sometimes it's the lack of experience of the attorney, and sometimes it's a combination of both. It all comes down to communication. No matter what, as a client, your estate planning attorney should absolutely be walking you through this conversation during the planning process. And if necessary, they should be talking directly to your financial advisor, if there is one, or otherwise verifying with you how your accounts are designated. Now, here's a key distinction. There is a big difference between planning to avoid probate completely versus setting up certain accounts to pass outside of probate. Some people go to great lengths to set up an entire estate plan that's designed for complete probate avoidance. And this is often done through the use of a revocable living trust. The difference in that type of plan is that very often the trust is set up to cover the costs that we're talking about here. Now, these plans are not as common in Pennsylvania for reasons that I go into in a video that I'll link in the description below, but many people use them. I've helped people set them up. I've helped manage plans for clients that were set up by another attorney. But this is a very specific type of planning, and it's a little bit beyond the scope of this video. I also want to be very clear about this. It is very common. I would say probably 95%, maybe even 99% of the plans that I set up for people, we are having them set up most of their accounts, or at least their sizable accounts, to pass outside of probate. Certainly IRAs, retirement accounts, because of the income tax issues. But we're looking at the bigger picture, and we're making sure that there's enough funding to pay necessary expenses, not to mention specific bequests that they might have in their will. And this is a piece that way too many people and their professional advisors are missing. We need to do better, because the cost of making this mistake is significant. The thing that hurts the most is that I know that the reason that people set things up this way is because they're under a mistaken belief that they're going to make things easier for the person that they've named as their executor. But in fact, the reality is that it absolutely makes things worse. This is a complex topic. I could go on for hours. There are a lot of other things that we didn't really go into too much detail on in this video. But if you take one thing from this video, it should be this: probate avoidance is not a goal. Good estate planning is a goal. Avoiding probate without planning can cause serious problems for your clients and for your loved ones. No matter what you do, my recommendation is to work with a reputable estate planning attorney and work with a financial advisor that understands your broader estate planning goals. There are a lot of attorneys who will draft a will for you. You can find templates online and draft a will yourself, but it's not the same as real estate planning. In the same way, many financial advisors will help you fill out a beneficiary form. But again, that's not the same thing as creating a coordinated, comprehensive estate plan. I'm not saying this to be critical. I just hope that it serves as a word of caution. A little extra planning now can save your loved ones a lot of stress, a lot of time, and a lot of money later. So I hope that this video was helpful for if you're a client. I hope that you can encourage the conversation and dialogue with your estate planning attorney or your financial advisor to try to round out the conversation a little bit. If you're a financial advisor and you're not already doing this, you absolutely should be talking to your clients about their broader estate planning goals to make sure that what you're doing for them, because it has a massive impact, is aligned with their broader estate plan. And if you're an attorney that's drafting wills, and this is something that an area of law that you want to continue doing or you want to get better at, it's critical to understand how your clients have their assets structured to pass at death. Because if your plan and the plan that was set up for them with the financial advisor are not aligned, it can cause a huge problem when the person passes away. So I hope that this was helpful, and I hope to see you in the next video.